like to welcome you to the final round of the 1983 Moot Court competition. We have a distinguished panel of judges for you tonight. Our Chief Justice is Justice Harry A. Blackmun of the United States Supreme Court. And on the panel will also be Judge Stephanie Seymour of the United States Court of Appeals for the 10th Circuit and Judge Harry Edwards of the United States Court of Appeals for the District of Columbia Circuit.
We'd like to introduce the finalists tonight. We'd ask you to hold your applause until all of them have been asked to stand and we'd ask you to from the opponents, the Raoul Lindbergh team, Ralph F. Boyd Jr., Kevin E. Gott, Sarah M. Lord, M. Howard Morse, Gary M. Reed, Michael J. Couture. From the Atticus Finch team, who the appellate tonight, Linda P. Bradshaw, Mark D. Director, Mark C. Dosker, Francis M. Halazubiak, Kelly A. Levitan, and Sheila M. Mossman.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of the United States is now in session. All those having business before this court, come forward, give your attention, and you shall be heard. God bless these United States and this honorable court.
I might say that the courtroom has shrunk since the last time some of us have been here. But next case on the calendar is number 83920, Hawaii Housing Authority and others against John Makalena, which comes to us from the 9th Circuit. I might compliment counsel on getting here from Hawaii after the earthquake. I trust by any chance is the land in question destroyed in the earthquake? I'm always looking for a way to dispose of a case and get on to the next one. I take it hasn't, and Mr. Rife, are you the first one up? And if so, when you're ready, we'll hear from you. You know, the real Chief Justice doesn't like this very well. There are some of us that are a little bit more broad-minded. Now, don't tell him that. Mr. Rife, if everything's calmed down, why, you may begin.
May it please the court, my name is Gary Reed. My co-counsel in oral argument is Sarah Lord. Our co-counsel on brief are Ralph Boyd, Kevin Gott, Howard Morse, and Michael Tutur. We represent the appellants, the Hawaii Housing Authority, its commissioners, and other state officials. In our federal system, certain matters have traditionally been left to state control. The issue on this appeal is whether the states should be free to implement and interpret state land use policy free from immediate federal supervision. The issue which I would specifically like to address is whether the Ninth Circuit erred in enjoining proceedings under the Hawaii Land Reform Act and in declaring that act unconstitutional before any state court could interpret it. Ms. Lord will discuss, if this court reaches the merits, the fact that the Hawaii Housing Authority, that the Hawaii Land Reform Act is constitutional, and that the Ninth Circuit erred in finding that act unconstitutional.
In other words, the Ninth Circuit was wrong completely across the board.
That is correct, Your Honor.
Is this a very important case?
It is, Your Honor. What is at stake here is a major legislative initiative. The Hawaii legislature, since the beginning of the state itself, has been concerned about the high concentration of land in very, very few landowners. For example, only 5% of the land is open for owning by 99% of the populace. These few landowners in the state have controlled the land and have driven up the prices of land because they've refused to sell the land.
But what I was really driving at is, if it isn't as important as you say it is, why does the Ninth Circuit not report its opinion? Why is it an unreported opinion?
Your Honor, it's a very good question.
What's the matter with the Ninth Circuit, or can't you defend them in that respect? Because you're attacking them here, aren't you?
I suspect that we wished it was reported because we consider it much more important than the Ninth Circuit did. In fact, we think that they should have abstained to let the state courts either to interpret the act itself, and that the Ninth Circuit's decision to rule on the act in and of itself does not show the importance of the act to the state of Hawaii. In fact, we believe that the principles of Younger v. Harris are fully applicable in this case. The state of Hawaii had already begun proceedings under the Hawaii Land Reform Act. They had already begun valuing the land to take that land by eminent domain. In Younger v. Harris, this court refused to interrupt state criminal proceedings, and when those proceedings were fully available for review in this court. Those principles have carried over to civil proceedings in general. In Moore v. Sims, the court found that child-parent relationships and the state's regulation of those relationships were important enough that those proceedings should be left to state control. Eminent domain is no less important. Land use planning and land use policies have traditionally been left to state control.
Is there any case, counsel, where the Supreme Court has endorsed Younger equitable restraint in an eminent domain proceeding?
No, Your Honor. The court has not embraced Younger abstention in this regard. However, under common equity jurisprudence in Kavanaugh v. Looney, this court held that the normal principles of equity would keep this court from enjoining state officials when those eminent domain policies could be reviewed in this court on appeal. It's important to realize, Your Honor, that in this case, the appellant, Mr. Makalena, has in no way claimed that he would be irreparably harmed by being left to state proceedings.
Is that what you have to show under Younger? Is the burden on the appellees to show that there would be irreparable harm?
The appellees need not show irreparable harm, Your Honor, but one of the underlying principles in Younger v. Harris was that when state proceedings are ongoing that implicate important state functions, as this court said in Huffman v. Pursue, then the appellee, or Mr. Makalena, should go beyond just private equity jurisprudence. Once the federal courts are being asked to enjoin important state proceedings that really go to the heart of what states are there to do, then...
But this proceeding really isn't that, is it? We're simply at the arbitration stage, and my understanding of the Act is that at this stage, only the value of the land can be determined.
That is correct, Your Honor, but what's really important to see here is that the arbitration is one part of an ongoing proceeding. The state of Hawaii has set out arbitration as a method of valuing the land. It's
and they
more
specifically
efficient.
say in the statute that arbitration is not part of the judicial condemnation proceeding.
That's correct, that it is in advance of, but they've
No,
made...
wait. What does the statute say on that? I thought,
Subsection.
correct me if I'm wrong, I thought the statute said very clearly, and I thought unusually, that arbitration was not in any way to be considered part of the judicial proceeding. Is that right?
What the state said is that, in 8B, Your Honor, is that it is not part of, but the entire sentence, if read in context, says in advance of and not part of. We interpret that, Your Honor, is set apart, and there's no way to say it isn't set apart. But what that arbitration finds is very important evidence, prima facie evidence. In Middlesex, this court had a disciplinary hearing, bar disciplinary hearing before it, and the disciplinary board found evidence that could be reviewed totally de novo later on. And yet,
Seems to me the state Supreme Court, if I remember correctly, the New Jersey Supreme Court said that the filing in Middlesex was tantamount to filing with the state Supreme Court, right?
that's correct, Your
That's
Honor.
not this case.
It's not this case in that it's not a filing with the court. And we understand that what we're asking for is a broader extension. But what's going on here is still important to the state. The state's method of valuing the land for eminent domain is part of the overall action.
The only Supreme Court precedent you've got is Mashuda, and Mashuda makes it very clear that this is not a significant state interest. That is, you can't meet one of the criteria under Younger.
The same day Mashuda was decided, Your Honor, this court decided Louisiana Power and Light v. City
Is
of
that
Thibodeau.
Pullman or Younger?
That was somewhat Pullman, but it was also...
Somewhat?
It was an unusual case in that there was no constitutional decision to avoid, and that's why I say somewhat Pullman, Your Honor, because...
Or was
one
it a
of-
dismissal or an abstention? You see, that's a critical distinction, isn't it, Younger and Pullman?
That is a critical distinction, and probably the critical distinction between the two. But what Louisiana Power and Light said, as did Kavanaugh v. Looney many years prior to that, was that eminent domain was important. Mashuda was dealing with a case in which this was a diversity case in which this court was basically applying unambiguous law. What the court said in that case, and Justice Brennan in later cases, was that they were not enjoining or thwarting state policy. They were just implementing state policy in Mashuda. However, in Thibodeau, and the analogy we draw from that, and in other Younger cases, what's occurring is the thwarting of state policy.
But Thibodeau is not a Younger case.
That's correct, Your Honor, but I understand that Thibodeau is not a Younger case. The key there is that there was still a discussion about how important eminent domain was, and that discussion carried over and cited previous precedents, Georgia v. Kavanaugh, Georgia v. Chattanooga, Kavanaugh v. Looney. Prior to this, general equity jurisprudence realized how important eminent domain was. And those are the cases we really draw on, the importance of eminent domain.
Don't we have a significant problem here because certainly the constitutional issue cannot be raised in the arbitration proceedings?
That's correct, Your Honor. But as the appellee conceded in the district court below on page 16 of the record, the eminent domain action must be brought within 60 days if the state is to take the land. There can be nothing affirmatively done to Mr. Makalena. His land cannot be taken from him until that eminent domain action is brought.
But that's a future action, isn't it? You're asking us to abstain in favor of an action that will not take place except in the future.
It is an action that is future in that the state has to file that action. But as we conceive of the entire statutory structure, it is one general proceeding that before the land can be taken, it has to be valued. Before the land can be taken, the eminent domain has to be officially brought to state court. And then at that time, before the land can be taken, he has to have an opportunity to raise his constitutional objections. And that's only 60 days after the arbitration award. And again, Mr. Makalena has not claimed that either A, he would be irreparably harmed in leaving him to that, or B, that the state does not provide an adequate forum in those 60-day period. So we realize that that is an extension, but the underlying policy of Younger v. Harris, that of comity and federalism, leaving the states to do what are important state functions for the state to do, we think justifies this. The state has set up a procedure. It's allowed innovative methods of dispute resolution. In the past, in State v. Coney, the state did allow the valuing of land to occur at the eminent domain proceeding. And at that proceeding, there was a 4-year time lag. And the state is just trying to do what a variety of district courts, federal district courts, have done. That being experiment with some of these alternative methods of dispute resolution. The judicial hearing itself has the characteristics of a judicial proceeding. Mr. Makalena can present his factual problems to that proceeding, and we realize that he has to go to the eminent domain action to raise his constitutional objections. But until this thing is done, until his land is actually taken, he's not been harmed. Section 12 of the Act allows him to continue to get the rents, continue to get interest from the land. He hasn't been harmed irreparably. In Kavanaugh v. Looney, this court said the mere threat or pendency of an eminent domain action does not harm a landowner irreparably.
But in the cases that you're relying on, at least with respect to Younger, like Middlesex, Traynor, and Vale, and Sims, all were cases wherein the state courts had yet to decide the merits of the issue, the constitutional question that was before the federal court. In this case, that's not so, is it? Because the condemnation, the decision to condemn or not, or the decision to take, has already been made.
The decision to file the condemnation
Well,
action.
the decision to take the property has
Correct.
been made, and that's what's being challenged, right?
I'm not.
The decision to take the property.
Okay, the decision to take the property has been challenged, has been made. However, and this is the interlap between a Younger and an Pullman, that decision may be inappropriate. As this court has noted in a variety of Younger cases, in particular Moore v. Sims, one of the threads that hits both abstention doctrines is that when a statute is coming before the court, a state court, and there are constitutional objections that can be raised to that statute, then we let the state court work out those kinks in their structure. And in this case, the HHA, the Hawaii Housing Authority, said, yes, Mr. Makalena's land should be taken. However, the state courts could think, and understandably so, that that the Hawaii Housing Authority possibly has not understood the limits of the Act. And those limits of the Act are set forth in Section 6 of the Act. The Hawaii Housing Authority can only take land if it will effectuate the public purposes of the Act. To determine what those public purposes are, one must look to what the to the underlying concerns that motivated the legislature. They weren't concerned about taking everybody's land over 5 acres or large leases. They were concerned about the scarcity of residential land in Hawaii. They were concerned about high lease rents. They were concerned about high prices. They may very well narrow this authority and tell the Hawaii Housing Authority, take into consideration the relative scarcity of land, the relative egregiousness of lease terms, all these other factors that motivated the legislature. You should take in those considerations. At that stage, the Hawaii Housing, the state courts have in some way seen the constitutional objections and narrowed the Act if they so desire. That's the heart of Pullman, but as this court has noted, that's also part of Younger. It's one of the factors in federalism and comity, letting the states work out the kinks in their own structure.
Well, you really have developed for us an exhaustion notion. That is, whenever you want to raise a constitutional question under 1983 and there's a possibility of being in state court somewhere, anywhere, you have to go there first. Is that your argument?
No, anything.
Where are the limits?
The limits are these. The state has initiated the action. This is not Patsy v. Board of Regents. In that case, the plaintiff, if he were to have any remedy, would have to walk into an administrative hearing and say, hear me. Mr. Makalena need not do that. He need only sit tight, hold on to his land, and 60 days after the arbitration, he's got his forum. He doesn't have to take any affirmative step. Moreover, though this is not, may not be, as the court may determine, not the classic judicial proceeding, it's not an administrative agency. Administrative agencies' jobs are not finding prima facie evidence for court proceedings. This arbitration's job is to find prima facie evidence for court proceedings. So when we take into consideration that we're not dealing with a case in which the plaintiff has to go out and search for either a judicial forum or a state forum or administrative forum before anything happens to him, and we're dealing with a case in which it is still in some way related to the judicial function, finding and taking land.
Is it administrative?
We don't think it is, for the reason that its purpose is to find evidence for the judicial proceeding. And the administrative agency's purposes are not to find evidence.
Isn't that evidence absolutely rebuttable in the judicial proceeding?
It presents a presumption, prima facie presumption, or a burden of proof presumption, and it is rebuttable. But that still helps the court's job. It makes life easier on the court because the arbitrators who by their nature are possibly more experienced, that's why they were chosen for the job, the arbitrators have less of a delay, it's less expensive. So even though it's rebuttable, it still helped the judicial proceeding in that it speeded things along.
Now, the reason I'm expressing some concern is I thought we said in McNary we want to make it very clear that in the Younger cases we're talking only about traditional judicial proceeding, not otherwise.
I think in the Younger cases, the court basically said that it was not willing to expand to administrative remedies, but I don't think it decided the issue. In fact, Justice White in concurrence and Patsy, left open the option of state-initiated administrative agencies. So that thought of when the state does something, when the state acts on you. The second area in Pullman that we think is appropriate is the appellees contend in some way that if the act does not in some way apply to Mr. Makalena, he can present his constitutional objections to this court. However, Harrison v. NAACP made fairly clear that in this type of case, if the act does not apply to Mr. Makalena, he should not be free to present his constitutional objections in the state proceeding itself. He should not be free to present his constitutional objections here. Let him bring his action let somebody else who it affects bring his action. My time is running quite short, and so I will sum up.
Let me ask one question.
Please.
Does the state of Hawaii have a certification procedure?
Your Honor, that I do not know. It appeared in reviewing the acts, it does not have such a procedure. But what is, I think, important is that the state of Hawaii, once an eminent domain action is brought, allows immediately to have that brought onto the trial calendar. Above anything else, the trial calendar takes precedence. On appeal, it immediately takes precedence. And if public use is questioned, that gets interlocutory appeal above anything else.
Of course, you know many states do have such a procedure.
Yes, Your Honor. More than a decade ago, Justice Black wrote, quote, that the national government will fare best if the states are left free to perform their separate functions in their separate ways, end quote. The Ninth Circuit did not allow the Hawaii courts to perform their separate functions. The Hawaii courts were not allowed to interpret nor implement the Hawaii Land Reform Act. This court should correct that lower court error and abstain from deciding the constitutionality of the Hawaii Land Reform Act.
Very well, Mr. Reed. Lord.
My name is Sarah Lord. The Hawaii Land Reform Act authorizes takings with the aim of breaking excessive land concentration in the state of Hawaii and making this scarce resource available to a greater number of people. Thus, the Hawaii State Legislature determined that these takings were for a public use, and that determination should be treated with great deference by this court. Eminent domain is a matter...
Why? You're going to tell us why.
Yes, Your Honor. Eminent domain is a matter of local concern. The determination of what constitutes a public use is very much a reflection of local conditions.
Of course, if you take that to the logical extreme, legislative action wouldn't be subject to judicial review at all, would it?
Well, Your Honor, the standard is deference to the legislative determination. And in fact, in Berman v. Parker, that deference was defined in the words that the legislative determination should be deemed well-nigh conclusive. The reasons for deferring to the legislature on a matter of eminent domain are that eminent domain is a matter of local concern, and the federal courts have chosen to recognize that the legislatures are particularly qualified to recognize the local problems and to devise the particular solutions which are necessary to resolve them.
Of course, haven't we heard this same argument in the abortion area, in the one-man, one-vote area, in the desegregation area, that the legislature are always the best informed about the local situation? And hasn't the court overridden that?
Your Honor, there are very good reasons for believing that a legislature may often be the best qualified spokesman for local concerns. It is true that the courts have sometimes overridden legislative decisions in the name of other values, whether federal values or constitutional values or individual rights. But eminent domain does not implicate those particular concerns, and the Hawaii Land Reform Act does not either. The state of Hawaii is managing its land problem. There is an excessive amount of land concentration within the state. This has been a fact of life in the state of Hawaii since well into the 19th century, and it has been a problem that the legislature has been aware of for quite some time. As a consequence of this excessive land concentration, people in Hawaii are unable to buy land. They are forced into leasing arrangements in which they must rent the land for a long period of time and build their own homes. The result of this system is that they're in some sense tied to the land and the victim of the landlord's rents. But even more importantly for the entire state, this stranglehold on the amount of land in the state of Hawaii has restricted development sharply. People are not going to come to the state of Hawaii knowing that there is such a shortage of land on which to locate their factories, their businesses, or even homes for their employees. Moreover, the consequences of this excessive land shortage are vastly inflated land prices.
Should I, as a judge, worry that the underlying economic theory doesn't make any sense to me? In other words, I don't think the goal can be achieved by the means employed.
Well, the legislature's decision to solve these particular problems by authorizing a series of takings should be regarded as the legislative prerogative, Your Honor.
Well, even though it's nonsensical to me, and I've read books that would suggest that this is silly and won't work,
Well, Your Honor,
I should ignore those
but perhaps I
instances.
should take issue with the first premise that you're making.
That I've read books. I'll leave.
I'll pass on that and get on to the economics. The state of Hawaii has a frozen land situation, and it has chosen not unnaturally to free up that land. It has chosen the method of eminent domain to do precisely that. The decision that land can be made available by authorizing a series of takings should be regarded by this court as a legislative prerogative, and the standard should be one of minimum rationality. This court has said that once the object of the legislation is within the legislative competence, the legislature's solution or decision on how to implement it should be left alone,
What should
essentially.
we do with Cincinnati versus Vested, where the decision, we said there that the decision on public use was ours to make, not the legislature? Final decision.
Well, in Cincinnati v. Vester, Your Honor, the court said that the decision of a public use was indeed a judicial inquiry, and no one disputes that. But in Cincinnati v. Vester, there was only a declaration that these takings were for a public use. There were no findings whatsoever, and there was nothing in the record on which the court could make a determination that the takings were for a public use. The decision of what constitutes a public use is very much a reflection of local circumstances.
So you're saying as long as the legislature says in more than a few words that this is for a public use, that's the end of the judicial inquiry?
Well, there's more than that involved, Your Honor, and particularly in this instance. As we've indicated, excessive land concentration has been a fact of life for a long time. Prior to passing this act, the legislature authorized a study which took place over a 3-year period. And that study focused on the problems of land concentration in Hawaii and their impact upon the economy of that state. On the basis of that study, the legislature finally passed the Hawaii Land Reform Act, deciding that takings were the best solution to that particular problem. So there's more than a mere incorporation of public purposes contained within the act. The legislature made a very sincere effort to investigate the problem and devise the best solution, and then incorporated its findings within its act.
Concerned about the private-to-private aspect of it, the transfer. Your opposition makes a strong argument that this is nothing more or less than private-to-private transfer of private property, and whatever public use we might be able to find is very remote and incidental. And there has never been a case like this before.
Well, Your Honor, it's certainly true that there has never been a case like this before. But the fact that there is a private benefit does not immediately turn a taking into a taking for a private use.
But is it the principal benefit? Is the private benefit truly the principal benefit? Unlike Berman, where it was incidental, that is, the private benefit was quite incidental to the taking. That's the case you're relying on. Here it seems like the private transfer here is the principal gain.
Well, Your Honor, first of all, in Berman, the legislature did make a determination that private ownership could in fact be a means of implementing the public use, so that the decision to make that transfer for the benefit of private individuals was a part of the implementation of the public use or public benefit.
Except there was a continuing governmental oversight in Berman that continued after the condemnation, right?
Ready to
Yes, Your Honor,
take
there
two.
Whereas here, it's simply going to be a transfer from the big owners to the small owners, and the government does not otherwise involve.
Well, Your Honor, the government has something more of a role than that. the Hawaii Housing Authority has the discretion to act on the petition of the lessees in whether or not to initiate the takings or not to act. The Hawaii Housing Authority can act without the petition of the lessees if it believes that the takings will effectuate the public purposes of the act. In essence, the kind of discretion that reposes in the Hawaii Housing Authority is of the type that is necessary to bring coherence to this large-scale scheme of effecting a transfer of land on a major scale throughout the state. On that basis, the Hawaii Housing Authority is a very necessary and important agent in what's going on. But at the same time, while it's true that the transfers do result in transfers to private owners, the real benefits of these transactions is not the immediate benefit to the lessee, but rather the consequences to the entire state of the opening up of the land market. What has happened here is that a scarce resource has been made available to a greater number of people. In that context, this case is very similar to the earlier irrigation cases, in which land was condemned for the purposes of making water available in greater quantities to a greater number of people. In both the irrigation cases and in this case, the rationale was the economic benefits that would flow to the state from those transfers.
How far do you go with it? Suppose the state had decided that in analyzing the situation here, we think that we would be a lot better off, make it any state, let's not use Hawaii necessarily. We've looked at Hawaii and other states. We think we'd be a lot better off if we had some big landowners, because they'll get wealthier and they'll put more money into the state and everyone will end up a whole lot happier, and we're going to have a 2-year study and lots of staff and lots of findings supporting all of that. And there's going to be a long statement in our statute saying we are now going to condemn any land owned by little people so that it can go to a few big people. And the rich should get richer because the state will prosper. Would that pass muster? And if not, why not?
Well, Your Honor, in the first place, it would require a very careful analysis of the local conditions. And to that extent, it does make a difference whether we're talking about Hawaii or Utah or New York, because the agronomy, the geography in those states varies, and it results in different types of economic.
All right, I don't want to let you
factors
off the hook that
considered.
easily. Let's put us in a state that will support my position, where there are more owners than the Hawaii.
Then I would, the court might find that it was public use, but the decision would have to rest upon whether or not the benefits of that transaction would result in greater gains for a greater number of people.
What is the court supposed to do in making that determination?
Examine the determinations of the legislature.
Are we supposed to judge whether or not the means used can really achieve that purpose?
With minimal review, Your Honor.
Well, that's what I'm trying to understand. Is there something different you're saying about my hypothetical than this case?
No, Your Honor, I'm simply suggesting that the hypothetical as you have posed it contains elements which could make this court's decision and a legislative determination quite different as well. That's on the public use question. But independently of the public use question, there is another brake operating on the state's eminent domain power, and that is the power of just compensation. It is also quite possible that the kind of transfer that you are discussing, one in which presumably a greater number of little people would be victimized for the benefit of a small number of big people, on the possible rationale that this would result in a greater benefit for everyone. But it is equally possible that the state would not be in a position to afford that kind of transaction. And there is a limit imposed on the state in terms of what it can and cannot do financially.
Why couldn't we use the Hawaii scheme and let the rich people pay the poor people?
Well,
That's all Hawaii's doing, right? Just
Your Honor,
letting-
there's more involved in
The
this.
state doesn't pay anything in the Hawaii scheme.
It's not entirely clear from the statute exactly what the role of the Hawaii Housing Authority is. In fact, if I could digress slightly, that might be a reason for abstaining, because it would allow the state courts to clarify the dimensions of the authority of the Hawaii Housing Authority. But I would also argue, Your Honor, that the Hawaii Housing Authority is authorized in a sense to oversee these transactions. Now, up to now, every single transaction which has been initiated has been settled either in the preliminary negotiation stage or at the mandatory arbitration stage. So there hasn't been a need for state finances to come into play. The Act does not, it is quite possible that once the transaction goes underway and the land is authorized to be taken, that the state will indeed have to appropriate money to take the land. First of all, to purchase it, and secondly, in the event that there are not sufficient lessees to buy it, actually to hold it, so that the state does contemplate, first of all, an initial financial outlay and possibly a financial loss, or at least a period of financial limbo in which it's simply holding the property in and of itself. And the statute says, I believe it's Section 81614, that the lessees at the end of the condemnation proceeding are in fact to buy it from the Hawaii Housing Authority. And we would argue that that suggests that there is a financial break on the part of the state that's present both in the statute and in this case as well. To that extent.
Is that critical to your case? Because no one below has found that.
No, Your Honor, it's not. We believe that these takings
Just
are...
want us to think about it in case it would...
Yes, that's right. We believe that these takings are for a public use because in determining that they were for a public use, the legislature considered precisely the kinds of problems that this court has equated with public purpose, public benefit, and public advantage, all of which have provided rationales for eminent domain takings. The state faced a severe economic problem. It also faced a problem in that its citizens were frustrated in their desire and ability to own land, and it chose to solve it by authorizing a series of takings under the Hawaii Land Reform Act. To that extent, the Hawaii legislature's determination of the public use is entirely consistent with this court's decisions. In addition to authorizing takings for a public use, however, the Act fulfills the additional requirement that takings must also provide just compensation. In 1976, the state legislature decided to implement another scheme, arbitration, whereby other state interests, such as conserving judicial resources and possibly arranging for these transfers on a more efficient and expedited scale, could be implemented. Thus, the arbitration proceedings, while part of the judicial proceedings, have the additional benefit of possibly conserving resources, both on the part of the state, on the part of the lessees, and on the part of the landowners who might or might not decide to settle, and thereby resolve the transfers on an easier basis for everyone involved. The just compensation that's provided for in the statute fits within those provisions.
Your opponents convinced at least one of these lower courts that there was not just compensation because of the length of time in the scheme that the legislature has provided for. In other words, a great number of months can go by before the arbitration process is finished and possibly an appeal from the valuation before you get to the state condemnation.
Well, very directly, Your Honor, there are indications in other state of Hawaii eminent domain cases that it takes as long as 4 to 5 years for an eminent domain proceeding to reach its conclusion. The lower court spoke of, I believe, 42 to 50 months for this particular proceeding. Under the present system, there is the added advantage, and it seems to be borne out by the facts that the previous 20 takings have been solved at the negotiation or arbitration stage, that they will get the compensation closer to the date of designation than they might in the 4 years that it would take in a regular full court action. Moreover, this court has said that that just compensation must be calculated from the time of taking, but recognizing the moment of taking has varied considerably from state to state and does not have to mark the end of the eminent domain proceeding. It can be from the time that the government signals its commitment to authorizing these takings, and that was indeed the gist of this court's opinion in U.S. v. Miller. There's nothing in the statute to say that just compensation must be calculated from the time of designation. In any event, whether it's calculated from the time of designation, the initiation of the mandatory arbitration, or the end of the mandatory arbitration, it still fits within the requirement that the government be committed to the taking, because under those circumstances it has clearly signaled its intentions.
Somebody else along with Seymour.
I see my time is up. So I will merely end by saying that we hope that this court will, if it decides not to abstain, recognize the particular history of Hawaii that requires these takings as being for a public use and uphold the statute. Thank you.
Take 4. Okay.
Thank you, Ms. Lord.
All right. Ready, 3. Ready, 3. Take 3.
This is Ms. Bradshaw.
Ready, 2. Take 2. Bill, I'm not gonna go to that yet because we'll stay on her since she's a new person.
May it please the
We'll
court.
stay on Rajiv.
My name is Linda Bradshaw, and I and my co-counsel
So,
Sheila
Bill,
Mossmiller are the attorneys for John Makalena, the appellee in this case. I will be arguing that this court should exercise its properly invoked jurisdiction and reach the merits of Mr. Makalena's constitutional claim. Ms. Mossmiller will be arguing that this court should then find the Hawaii Land Reform Act unconstitutional as a violation of the Fifth Amendment requirements that land only be taken for public use and with just compensation.
Okay.
Mr. Makalena's land has been designated for redistribution to the lessees of that land under the Hawaii Land Reform Act, a statute which he believes is unconstitutional under the Fifth and 14th Amendments of the United States Constitution. He has properly invoked the jurisdiction of the federal courts to seek protection from this unconstitutional state action, and it is the role of the federal courts as the primary protectors of all rights under the federal Constitution to hear his claim. As the District Court and the Ninth Circuit Court of Appeals found, abstention, which is a narrow and extraordinary exception to this court's duty to hear cases properly before it, is inappropriate in this case, where a federal decision will interfere with no ongoing state judicial proceeding and where the challenge statute is clear and unambiguous. Because abstention is an exercise of judicial discretion, this court can overturn that finding only if it finds that there was an abuse of discretion.
That's a faculty member off to your
We believe the lower
left.
courts
Focus.
properly found
Get him
abstention
in
under the
shot.
doctrine of
Okay,
Younger v.
faculty
Harris to be
member number one,
inappropriate
right
in
there.
this
All right,
case.
hold it, Julia.
Younger abstention
Very
has been
nice.
found
We're gonna
appropriate
go
only
for
where a federal
as a
decision
reaction.
will interfere with an ongoing state
Okay,
judicial
hold it, 2 and
proceeding
4.
implicating important state interests. In those cases, it was feared that it would show disrespect for the state judiciary for the federal courts to interfere where the plaintiff had an adequate opportunity to
Very
protect his
nice.
rights. Younger abstention
Okay,
is
Julia, back
inappropriate
on
in
your
this
judges.
case where the
Okay,
only
another
ongoing proceeding
reaction in a
is an
bit.
arbitration between privately appointed arbitrators
Julia, on-
empowered
yeah, on
only to hear
Blackmun
the
and
fair,
Seymour
determine the
instead,
fair
because
market
they're
value of
editing
Mr.
Blackmun
Makalena's
and
land, not the constitutionality of the statute under which his land has been designated.
But why isn't that a
Ready,
similar
4, take
proceeding
4.
as in Middlesex, where the court viewed
Bill, can
the
you
ethics
give me a
committee
close-up of
as special type of special master?
Well, in that
Focus.
case,
Ready,
Your Honor,
2, take
the New Jersey
2.
Supreme Court considered the Ethics
Run
Committee
through
to
your
be
focus,
an
Will.
arm of the judicial system of the state of New Jersey.
Okay,
And
back
because
again.
the Hawaii
Hold it
Supreme,
right
the New
there.
Jersey Supreme Court considered it to be so, this court respected its
Hold your shots,
determination
everybody.
and deferred to that as it would to the state judiciary.
can
But
tilt.
hasn't the Hawaiian
Ready,
legislature in
3,
effect
take
made
3. Never
arbitration an
mind tilting.
arm of this proceeding?
Ready,
Not
2,
exactly, Your
take
Honor.
2.
The Hawaii Supreme Court has stated that it does encourage arbitration as a means of settling disputes short of litigation. However, that encouragement does not transform this non-voluntary proceeding into a judicial proceeding. This panel was not appointed by the courts, nor was it delegated authority by the courts.
Shots are looking
It was
good,
rather
everybody.
a function of a legislative scheme through
Let's
which
try a
Mr. Makalena
reaction
and the
shot
lessees
on
were forced
3.
to appoint
Hold
arbitrators
your shots.
themselves to undergo this proceeding. This court should not hesitate to interfere with a
Ready,
proceeding with which
3.
the state courts are not involved.
Take 3.
Respect for the state judiciary does not warrant such
And
extension.
ready.
You can't
2.
bypass this
Ready,
arbitration
4,
procedure
take 4.
and go into court on
Oh,
a
hold
question
it,
that the
hold it.
arbitrators have to decide. can you?
No,
have
you
to
cannot
Ready,
bypass
2.
it, but that is a legislative
Take 2.
determination and not a judicial determination. And the Younger Doctrine
Okay,
was
Bill, that
created
looks
to
good.
avoid the appearance of disrespect for the judiciary and interference with the state judiciary,
Okay.
out of the belief that the state judiciaries are equally capable of protecting rights as are the federal judiciary. But an arbitration panel empowered only to determine the price which is to be paid for land
Looking
is
good.
not the same sort of proceeding with which this court should be reluctant to interfere.
Ready.
Would it make a
3,
difference
take
if we were at the
3.
condemnation stage?
Ready.
Yes, Your Honor, we
2,
believe it would
take
make a great
2.
deal of difference. If the state had instituted condemnation proceedings against Mr. Makalena and they were in state court, we believe that Younger abstention would be appropriate.
I don't understand the difference.
Ready. 3.
Isn't that
Because-
a facile argument, isn't it?
No, we don't believe so,
Back
Your
to
Honor,
2.
because
Hold it,
they
Reggie.
have
I
acted.
didn't think you would.
Cutting between 2 and 3.
The state has designated his land, but
Very
the
nice.
state judiciary has not yet stepped in. Mr. Makalena has been harmed by this designation and seeks a declaration by this court that the statute under which the state is already acting is an unconstitutional one. But the state judiciary has not yet been brought into play, and as such, it is this court's
Okay,
role
reaction shot on
to
3,
decide the
hold
question
3.
before it, because there is no justification for denying Mr. Makalena his chosen
Ready.
forum.
2, take 2.
Doesn't the Hawaiian Supreme
Ready,
Court
4,
consider
hold it,
arbitration
4,
proceedings
hold it,
quasi-judicial?
take 4.
Yes, Your Honor, it has stated that
Ready,
it finds
2,
voluntary
take
proceedings
2.
to be quasi-judicial. The theory
Ready,
behind that was
three.
because where the parties have chosen to submit their
That's good,
disputes to
Julia. Frame them up.
arbitration, they have incurred in that all
Ready,
of the
three.
risks which come with arbitration, including
It's a
that the
nice shot,
arbitrators
Reggie.
may make an erroneous finding of law or
Photogenic
finding of
oralists this
fact,
year.
which is essentially unreviewable.
Ready,
But where the parties have
three.
voluntarily chosen to
Hold it, Reggie.
substitute
Come on here.
arbitration for the judicial proceeding, the Hawaii courts have respected that and have very severely limited the review which they will give to those proceedings.
I don't understand
Ready,
why the voluntary,
three, take
involuntary distinction makes a difference.
Ready,
I mean, you seem to
two.
say in your brief that because it's a mandatory proceeding, it isn't judicial, but I don't know of too many defendants in lawsuits who are there voluntarily.
No, they are
Ready,
not, Your
two.
Honor. However,
Take
we
two.
believe that the only
me
reason,
less
the
headroom.
reason why
Give me
the
less headroom,
voluntariness
Reggie.
issue came up is
Tilt
because
down slowly.
of the assertion that the Hawaii
Okay.
courts consider these
Very nice.
quasi-judicial and that therefore so should this court. The reason we discuss voluntariness is because
Hold
the
your-
Hawaii
hold your
courts have
shot, Reggie.
considered these proceedings to be quasi-judicial only where they were voluntarily chosen by the parties.
Okay,
There has
very
not
nice.
been a case cited by the appellants
Ready,
or one
three.
which we found in which the court used
Or
that
four.
same term to refer to an arbitration in which the parties were not there voluntarily.
Rajiv, keep
Therefore,
your
we
shot
believe
very
that this
still.
court should step in and test the statute against the Hawaii
Rajiv,
the
keep your- no,
federal
I'm not gonna do a
Constitution.
split.
Excuse me.
Ready,
We also believe that the
Four.
abstention under the
Ready,
doctrine of
nothing.
Pullman, Railroad Commissioners of Texas v. Pullman, is inappropriate in this case. The
Girl,
statute here
let's
is
see your
clear and
side
explicit.
view of the
The legislature
oralist,
has
please.
stated that it finds that the taking of land from landowners for the benefit of the
Focus.
lessees of that land is a taking for
Okay,
public use.
hold it.
Mr. Makalena seeks to challenge that explicit legislative statement as constitutionally insufficient under the Fifth Amendment. The question before
Ready,
the court
three.
is clear and is uncomplicated by unresolved state law. So the
Take
question is
three.
whether the statute on its face is unconstitutional.
Why
Ready,
shouldn't we let
four.
the Hawaiian Supreme
Take
Court
four.
decide under the Hawaiian Constitution whether it's constitutional?
Well,
Ready,
Your Honor,
two.
this court has
Take
consistently
two.
refused in the past to abstain merely because the plaintiff could have
Hold
sought
your
relief under a
shots.
similar provision of the state constitution. It is true that this may be unconstitutional under both the Hawaii and the federal constitutions. However, Mr. Makalena has chosen to seek protection under the federal constitution, and to deny him
Ready,
his
two.
chosen
Ready,
remedy would
three.
be to deny
Take
congressional
three.
intent in giving this court jurisdiction over all federal questions, that these courts should be the primary protectors of all rights
Ready,
guaranteed by the
two.
Constitution.
Take two.
This
In
court-
effect, you were
Ready,
saying that
four.
he has a
Take
right
four.
to a constitutional decision out of
Ready,
this
two.
court,
Okay,
even
Bill, you
though
can lose her.
it's possible that the Hawaiian
Ready,
Supreme
two.
Court would find in his favor under the Hawaiian Constitution.
Ready,
Yes, Your
two.
Honor, we
Take
believe
two.
so. He has chosen to seek protection under the federal Constitution. While the Federalist system provides two strands of protection, the state constitutions
Shots are looking
and the
good,
federal
everybody.
constitutions, he has chosen his remedy, and Congress, in enacting 1983, intended for plaintiffs who feel they've been harmed or their rights under the federal constitution have been
I need
violated to
somebody
come to
to
this
cover
court without
Edwards. You're
first
both,
seeking
Julia.
to fulfill any state
Oh, all right,
remedy.
never mind.
The
Julia,
existence of an
Julia, stay
alternative
on your
state
shot.
remedy
Okay,
should
Bill,
not be allowed to
give
thwart
me a-
congressional
yeah,
intent
Edwards
in making
and
these courts
Blackmun.
the courts to hear his claim.
Ready, three or four.
Surely
Ready,
the
three.
statute is
Ah,
somewhat
good call.
ambiguous on the just compensation issue,
Focus
isn't it?
looks a little odd.
Well,
Ready,
arguably it
two.
is ambiguous.
Check your
However, we
focus,
believe
Bill.
that resolution of that ambiguity will not alter
Yeah,
Mr.
okay.
Makalena's claim,
Ready,
and that
three.
therefore this court
I think
still should not
Blackmun is
abstain. But
winding
first,
up.
this court should not abstain for that ambiguity, because before reaching the just compensation provision, this court should decide the question of whether this
Okay,
statute
Julia,
takes
we'll-
for a
we'll
public
gamble.
use. It is not necessary to determine the ambiguity in the just compensation provision prior to deciding whether or not any takings, whatever compensation paid, are constitutional under this statute.
Well,
Ready,
if we
two,
really are
three,
confronted
take
with a
three.
case, as your opposition says, it's really a first impression, and you agree there is ambiguity, significant ambiguity
Julia, can
in
you give me
an
Edwards?
important part of the statute, that is just compensation. Even if you're right, that if you prevail on the
Ready,
first
four.
question,
Hold it, Julia. Take four.
that might end it, we'd never get to just
Ready,
compensation.
two.
Isn't that good reason for the court, at least under Pullman, to abstain, because we'll still have the case?
We're on four.
And he
Ready,
can
two.
reserve his federal question, your client can reserve the federal question under England. And once the state has told us whatever the state feels, then he can come back to federal court.
Well, Your Honor, we believe it is
Take two.
unnecessary to do that if you don't reach just compensation. And even if you reach the just compensation issue, we believe that no matter how the Hawaii courts construe this statute, the just compensation provisions would still be unconstitutional, and that therefore abstaining to allow them to resolve the ambiguity would serve no purpose. The statute locks in compensation, the date of valuation, within a limited range. The latest at which the Hawaii courts could construe compensation to occur is the date of the arbitration, since that is where valuation itself must
Rajiv,
occur.
pull back
Mr.
a
Makalena's
little. You're on
claim
the air.
is that
Do it
even
very
that
slowly,
date,
but let's
which is
make
the
it a little
latest date the
smaller, and
Hawaii
I wanna
courts
set
could
up a
construe the
split here.
statute to value at, is too
Pull
soon
back,
and does not
slowly,
provide
very
just
nice,
compensation.
Very nice.
Well, I know this isn't your side
Ready
of
for,
the argument,
take
but is
four.
that entirely true if there's a rebuttable presumption on what the arbitrator's
Ready,
value is?
two.
Doesn't that suggest that the valuation date can
Okay,
be
we're good.
significantly later than what you're arguing?
Rajiv,
if
ease
the
her
court
off to the
overturns it?
left.
But the date,
We're gonna do a
the
split.
judge can step in and
Okay, 2 and
overturns
4.
rebuttable presumption, but we believe that, for one thing, the presumption is very strong.
2 and 4,
But
you're
also
on
that
the
the
air.
value that's coming in as evidence is value which is improperly timed, and it's unclear that the federal
2 and
plaintiff
4
would have an
on the air.
opportunity, or that Mr. Makalena or any plaintiff in the eminent domain proceeding would be able to overcome that presumption and convince the state courts that the valuation date itself was wrong,
Okay,
when
we're
what the
gonna
state
lose
court would
4.
probably more be looking to was whether or
Back
not the
to 2.
valuation at the date at which it was taken place was
Okay,
one that
Rajiv,
was
You're
move
saying the
off to
court
the
would not
center.
use a later
Ready,
date.
4,
They would only make a
take 4.
decision as to the value as of the date that the arbitration board.
It is uncertain what the state courts would do.
We should
That
abstain
is
then.
Have a
possible.
close-up of
Well, Your Honor, we do not
Edwards.
believe it is so, because even if they, the fact that a federal
Ready,
state
3,
court could correct
2,
the error
just a little
in
quick
an eminent
chuckle there.
domain proceeding does not
Yeah.
compensate for a
She's
statute
probably
which is
lying.
written so that it values substantially too far in advance of the date of taking, and that we do not
let's see,
believe that the fact that a
Julia,
court could
let's
come in and
see
maybe
the rest
overturn
of-
that
let's see all
is
3 of them
sufficient to
in
make
case
up
somebody
for an
else
unconstitutionally drafted
does
statute.
something.
Nor do we believe that this statute could be construed in such a way as to make it inapplicable to Mr. Makalena's
Okay, we're
land
ready
and
for
thereby
whatever happens
obviate
there.
his need to be in federal court. The restrictions which the appellants assert could be read into the statute are ones which would defeat the explicit purposes of the statute, and the statute therefore cannot be legitimately so construed. The appellants assert that the court might find that only landowners who charge egregious rents, or that only
Ready,
landowners
3.
who own
Take a
large
reaction on
parcels
3.
of land should have their land designated.
Hold it,
However,
3.
the legislature explicitly stated
Okay.
that its purpose was to allow all individuals who are leasing the land on which their homes
All right,
sit
back on
to
2.
have an opportunity to own that land in fee simple. To say that only landowners, lessees who are paying very high rents, or who are leasing from very large landowners should have that opportunity is to thwart the will of the Hawaii legislature,
Ready,
and the
3.
Hawaiian courts should not construe the statute so narrowly as to defeat its intended purposes, nor should this court abstain on the possibility that a federal question will be avoided by an unreasonable construction of the statute by the Hawaii court.
Well, then wait a
Ready,
minute, what
3,
authority
take
does
3. Okay,
the
frame it up
housing
a little
authority
better,
have
Bill.
then
Oops, hold
to
it, thank
decide
you.
not to proceed? You're arguing as if they have no authority at all as
Don't
long
lose
as
them
there's a
off the side
majority.
of your frame. Stay with them.
Lessees who
Okay,
want to
hold
go
it
along,
right there.
it's a buyout.
We believe that the purposes
Ready,
of the
2,
statute are
take
so
2.
broad that there
Okay,
is
raise
very
your
little
foot
that
around
the
the side of your
HHA,
frame
very
and
little
then we'll
reason
do
the
a split.
HHA would have to find that a taking does not
Okay.
effectuate those
Bill,
purposes.
ease him
But
off
we
to
have
the
to
right.
agree with you that there is no
Okay,
discretion
hold
to be
it.
exercised
Hold it
by
very
the
nice.
housing
We're gonna
authority
do
in
the
order to
split.
buy your argument.
There is some discretion
that's
to be
beautiful.
exercised in that they want to make
Very
sure that
nice.
lessees are
We're
able
on
and
2
willing
and
to buy the
3.
land,
That's
and that
looking
the
good.
lessees meet the explicit statutory requirements to be able to purchase the land, that they're 18 years of
Okay,
age,
hold
that they
those
live on
shots.
the
They're
land,
looking
that they
very
have a
nice.
house on the land. Therefore, the hearing to effectuate the public purpose, at that hearing the HHA determines all of those things. However, where all of those are present, for the HHA to choose not to designate may be in its discretion, but to read restrictions in that require it not to designate would be to read in restrictions that are
2 and
contrary to
3,
the
you're
intent
still
of the
on the air.
legislature in enacting
Shots
the
are looking
statute.
very good. Don't lose him, Bill. Okay, we're coming back to 2.
Mr. Makalena has chosen to
Okay.
seek protection under the federal
Very nice,
constitution
everybody.
in the
That looked
federal
pretty.
forum. This court should hear his case and should find that the
She's
lower
winding
courts
up.
did not abuse their discretion
Julia,
in
let's have a
exercising
close-up of
improperly invoked
Blackmun.
jurisdiction over his claim. Thank you.
And Bill, let's have a switch of the oralist or whatever you can give me. Ready, 4. Take 4. Okay, Bill, that looks good. Now Sheila. Okay, we're getting on Sheila.
Ms. Mossmiller?
May it please the court.
2.
My name is
Take
Sheila
2.
Mossmiller,
Okay.
and I will argue that the
Looking
Hawaii
nice.
Land Reform Act is
Okay, Bill,
unconstitutional
not yet
because
on
it
that
takes
one. Let's
land
get
for a
back on.
purely private use and fails
That's
to
three,
provide
so
just
that's good.
compensation.
That's good.
What
Ready
provision of the
four,
Constitution
take four.
supports that statement?
The Fifth
Ready,
Amendment of
two.
the Constitution, as incorporated
two.
to the states by the 14th Amendment, Your Honor, requires that land be
Tilt down
taken
a little, Bill.
for a public use and with
Okay,
just
that's
compensation.
right, we get the sign.
Well, I'm reading
Ready,
from it. It
four,
merely
take
says, nor
four.
shall
Okay,
private
Bill, a little
property
closer.
be taken for public use
Little
without
closer,
just
Bill.
compensation.
No,
It
that's
doesn't
it,
say
okay.
anything about taking private
Focus.
property for private use.
Ready, two.
Well, Your Honor.
Maybe you can take it, so far as the
Ready,
Fifth
three,
Amendment is
take
concerned,
three,
for
and
private use and not
ready,
pay for it.
two. Take two.
I suppose that's one reading of the federal Constitution, Your Honor.
Three, sorry, ready, two. Take
However, we would argue that
We're on two.
only takings for public use are allowed by the Constitution and that the state must provide just compensation.
There are cases
Ready,
that support
three.
Yes, sir.
Take three. And two. Okay.
The stark question presented to this court
Julia, why
tonight
don't you
is
give
whether
me
there is
an
any
audience?
substantive limit on the
Any
power of the
groups we
state
haven't
to
covered
take
there?
private property. To answer this question, this court should review the determination of the Hawaii legislature that land taken under the Hawaii Land Reform Act is indeed taken for public use. The question here is whether the legislature acted constitutionally, and to defer to a decision that may have been unconstitutional simply because it involves questions of local land conditions, we believe would be highly improper. It is this court's role to protect against unconstitutional encroachments by the legislature against the public, and to merely defer would abrogate
Okay,
that role.
hold it.
Are you really
Hold it right there,
attacking
Brooks.
the legislative fact findings? In
Ready,
other words, the
three.
reasons given
Okay.
for
Over,
the
three,
statute?
Iggy,
I got the
Seymour,
impression
thank
from the
you.
brief that you're not really claiming that there would
Ready,
not be
two.
some economic benefit or some social benefit.
Well, Your Honor, the findings of the Hawaii legislature merely stated that
Okay,
there was a
ready,
problem
four.
in Hawaii. We believe this court could assume all the findings that the Hawaii legislature stated and still
Ready,
not believe that their
ready,
remedy of taking land under this
Audience
statute
reaction
is
on four.
constitutional. Therefore, local conditions alone do not provide a reason for
Ready,
deferring
two.
to the state legislature on this matter.
We're back
So
on
you don't
two.
mind if we
Julia, back
defer
on the
to their,
judges, please.
those
Ready,
particular
ready,
legislative
three.
fact
Take
findings? You
three.
just object to their conclusion that that constitutes a public use.
And
Exactly, Your Honor.
Ready, two.
I don't understand the scope of
Ready,
review.
four.
What is it we're talking about?
Take four.
Well, Your Honor,
Ready,
the Hawaii
two.
legislature
Take
found
two.
that
Give you guys a
there was a
workout.
public use in taking
Bill,
this
let's
land
have
to put it in the
Blackmun.
hands
All
of
right. Okay,
lessees.
give me Judge.
This
Yeah,
court, the
Edwards
scope
is
of
good.
review is that the court should be able to
Julia,
find that there
give
is a
me
public use or
Blackmun
is
and
not.
Edwards.
This court does not defer entirely
be
to the
far
decision,
apart.
the conclusion of the legislature that there was a public use, then this court must
Okay,
determine
sure.
whether the constitutional limitation of public use has been met.
Well, I thought in Berman there was a very, very
Ready,
strong
three,
language
take
by the
three.
court suggesting that, virtually suggesting, as long as the legislature took some time to state what it was that they were doing, and it was
Ready,
not wholly
two.
untenable, that we have to defer. That's their judgment
Ready,
to make.
two.
Well, Your Honor, we would
Take
note
two.
that in Berman, that the challenge was not to the particular public purpose of the act, and therefore there was no charge that the legislature had acted outside of its power in passing this. The charge was that the challenge was to the application of that purpose
Ready,
to a
four.
particular piece of land, and although the court spoke about the entire purpose behind the act, the challenge that they were dealing with and that what they said was well nigh conclusive was the legislature's determination that this particular piece of land was needed to accomplish that purpose.
And yet, is it not true that in Berman,
Take four.
as
Hold it, Julia, you're on the air.
Justice Edwards points out, that
Can
the
you zoom
court,
in?
through
Zoom in on
Justice
Blackmun.
Douglas, said that the role of the judiciary in this area,
Okay, hold it right
and I
there,
quote,
looking very
is an
nice. Hold your
extremely
shot.
narrow one.
Hold your shot. Looks
Yes, Your
very
Honor.
good.
True.
Ready,
But where the
two.
the
Take
court also
two.
said that,
all
subject to
your shot.
specific constitutional limitations, the decision of the legislature is well nigh conclusive. We would argue that this is a constitutional
Bill, is the
limitation.
D
The
all
legislature
visible
simply
on your
cannot
shot?
choose
You wanna
to
see
act
if you can-
unconstitutionally merely because it recites the magic words public
Ready.
use.
Now, that
Four.
sounded
Ready.
circular.
Four.
Excuse me?
What's the specific,
Okay, yes,
Division.
Julia.
The court-
Ready, four.
well-
apart from
Ready, four, take
what
four.
Berman was looking at
Ready,
and what we're
two.
looking at?
Take
We
two.
believe, Your
No,
Honor,
good,
that
Bill.
what the court
He's
meant
not
in that
cooperating.
case was that, subject to specific
We'll forget about the
constitutional
D.
limitations, we could defer
Not
to the
photogenic
legislature.
anyway.
However, whereas here, the challenge is to the constitutionality of the legislature's
Okay, Bill, that
action.
looks nice.
But you said the public
Ready,
interest
four.
requirement was a
Take four.
constitutional limitation.
Ready,
Public
two.
use requirement is a constitutional.
You're distinguishing that from public interest?
Yes, Your Honor, we believe that public use does not mean
On
the same
two.
thing as public interest.
And that's what
Ready,
you're assuming the
three.
court in Berman.
On three.
Well, it's not clear
Two.
exactly what the
We're
court in
gonna be
Berman meant, Your
cutting
Honor, because
between
that was
these guys.
an overlap of the police power
all your
and
shots.
the eminent domain power.
Well, Justice
However,
Douglas
we-
wouldn't like you to say that.
Four.
He wrote Berman for a unanimous
We're on
court,
four.
and
Ready, two.
Your Honor, we
Two.
simply
We're on
believe
two.
that regardless of the words
Okay, that
of
looks
Berman,
nice.
that conclusion would
Hold
be
all those
untenable,
shots.
that it would simply be an abrogation of this court's role to protect against legislative encroachments for the court to simply defer to a legislature on its
Rajiv,
conclusion of
next
public
time I'm
use.
off your shot
And therefore,
even
this court should not
momentarily.
do
Give me a
so.
little wider
What are
shot
we
of
supposed to look
ready,
for then? What
three,
is it?
Take three.
What is the
Give me
test?
a
Is it
wider
strict
shot of
scrutiny?
Sheila. That's
Excuse
it.
me, strict scrutiny?
Tilt down a little.
Well, Your Honor,
Hold
this
it.
isn't like an
Ready,
equal
two.
protection case where
Take
there are
two.
levels of scrutiny.
Very nice.
I believe in this case that the court
Okay,
will either
Bill, you can
find
go
that
in
there
on
is a
them.
public use or that there is not a public use, and that there are no levels of
Ready,
deference.
three.
No levels of deference that
Take
we
three.
see in any of these cases. Don't the cases really suggest that there is a high level of deference?
This
Ready,
court may
two.
defer to the legislative findings of fact, Your Honor, but should not defer to the legislature's conclusion
The ultimate conclusion.
that the takings are for public use. We argue that this remedy is simply not a constitutional way to deal with the problems which the Hawaii legislature has found, and therefore this court should
Ready,
not do
three.
Is that a
so.
least
Reaction
drastic
shot
means
on
test that
three.
you're incorporating now that I haven't
We're
seen in any
going,
of these
we're on
cases?
three.
I don't believe any of the cases
And
spoke about a scope of review,
back
Your
to
Honor.
two.
Perhaps
Audience is
where
getting
this
restless.
confusion comes from. I believe that the court will either find that there is or is not a public use. If the court wishes to assume...
But is it critical? Because you
Ready,
just were
four,
making a
take
least
four.
drastic means argument. Are you suggesting that if we can think
Check
of
your
another
focus,
way
Julie.
that the state could have done it,
Hold your shot, but check your focus.
then they
That's
should
good.
have, because we
Okay.
think that this is an oppressive way.
Ready, two.
And that's and that
Ready,
is
two.
implicated
Hold
in the
your
public
shot,
use
Julia.
determination too?
Well, Your Honor, we're not
Take
asking this
two.
court to find
Okay.
whether there was a
Nice.
less drastic means.
Three, your
We're
shot
only
looks
asking
good.
this
I'll go
court
to
to
you in a minute.
find that this particular way of accomplishing, of dealing with these problems is unconstitutional because it does not take for a public use.
Ready,
Indeed, the only use to which this
three.
land is put is a private one.
Ready, three.
The
Take
Hawaii Land
three.
Reform Act
Black.
takes explicitly
Whoops. Don't
for
leave them.
residential use,
Very
and
nice.
that is
He's
the only
checking
use
something
to
in
which
his
the
notes.
land
Ready, two.
shall be
Take
put
two.
under the Act. The land is merely given to lessees who will continue
Julia, you
to
can
live
try getting
on the land.
Blackmun. Looks
But
like
that
he's
was
got
implicitly, at least in
Oops,
Berman,
Julia,
part of
get-
the use.
get to
Some of the
Seymour.
urban
Ready,
renewal land
four.
was
Take
sold
four.
back
Hold it,
for
hold it,
private
Julia, hold
use,
it.
was it not?
Okay.
Well,
Ready,
but Your
two.
Honor, we would argue that
Take
in that
two.
case, the use by private persons provided a great deal of public
Bill, let's
benefit,
have,
and the
uh,
benefits to
Blackmun
the
and
individual
Seymour.
people who actually owned the land was a minor benefit when compared to the benefit to the public
Ready,
from
three.
the urban redevelopment. The use in this case, however, is a purely residential one. There is no other use contemplated, and we would argue that a residential use is the ultimate in a private use. There is no benefit to anyone other than
Ready,
people
three.
who actually live on the land.
Reaction on three.
This
What is
court-
it that the, excuse me, Counselor, what is it
Julia.
that the state
Ready, four. Take
could have
four.
done to overcome the objections that you're raising and to get land
Good, Bill.
transferred?
We'll get it in a minute.
Well, Your Honor,
Ready,
the
two.
state could not have
Take
done
two.
anything like taking land in a
Ready,
condemnation
three.
proceeding or forcing people to transfer land.
So you're saying a private to
Three,
private,
take
as you
three.
call it, private to private taking is by itself
Ready,
without
two.
a single additional inquiry unconstitutional.
No, Your Honor.
Two.
All right, well, then
The-
tell me
We're
how
gonna
you
be
can do it.
cutting.
If there were to be a benefit from the use of the land that would provide a benefit to the entire
good,
public,
Julia. Frame
then
those-
perhaps
frame the two
such a
of them up.
taking would be constitutional. However,
Ready,
whereas
three.
here, there is a private transfer between private individuals,
Check your
merely a
focus, Bill. I
change in
think you are in
ownership,
focus,
with
but
the
just
only
double
benefits
check.
to the public
Whoa. Go
being
back to
indirect
ten.
and insubstantial and accruing only from
Ready,
the change in
three.
ownership, not the change in use, that should be
Ready, three.
unconstitutional.
Dissolving to three.
If the state wished to deal with its problems, we believe there are other means by which it could deal with the problems. For example, if the state's concern is with the
Take
high
two.
rents charged on these lands, then the proper remedy would be some kind of rent control, if that's your question, Your Honor. Then.
You're back to least drastic means again.
Ready,
Well, we're not asking this court to find if there is a
And
least
two.
drastic means, Your Honor. We're only suggesting, as I believe you asked, that there are some other ways of dealing with this problem. We're only saying that this particular way, no matter how big the problem is, this way of dealing with it is unconstitutional.
That's what I was asking, without more, you seem to be arguing. This is, it
Ready,
can never,
three.
the
Take
state
three.
could never create a system to achieve what they've
Ready,
attempted to
two.
achieve here.
not by taking land from one owner and giving it to another for his private residential use.
Ready to?
You
course you're-
concede,
Please go ahead.
On
you
Seymour.
concede that the state
Ready
can
for?
regulate
Take four.
the use of the land,
Bill, you
for
can get on
example,
Seymour.
putting a lid on rents. Isn't
Seymour
that,
and
in effect,
the two
more
shots,
harmful?
right?
Because the compensation
shot,
that you'll
looking very
receive from the
good.
land will be more severely limited than in this
Ready to?
case. And if the state can do that, why can't it do what it's doing in this case?
Rajiv, you can get in
Well,
tighter
Your Honor,
on
if
it.
the state were only to regulate the use of the land, it would
Ready
not be
to?
actually taking the title
Take
to
two.
the land
Hold your
away
shot.
from anyone.
Hold your shot right there. Looks good.
Furthermore, they would not be giving it to someone else for the private use. There are certain attributes of ownership which the state
Rajiv,
cannot
ease her
simply
off
pay
to
for
the
by
left just a
compensation.
little
And if the
bit.
state is going to
She's
actually
talking
take
off
land
the
away
side of
from
the
one person,
screen.
it must have a public
Okay, hold
use
it right there.
in doing so, and must contemplate a public use. This statute contemplates only a private use by the lessees.
Suppose there are arguably tenable
Let's
findings
get Edwards
that
ready
the
for. Take four. Hold it, Julia.
state has made that will show that if they can
Ready,
achieve these
three.
transfers, the
Take
overall
three.
wealth of the state will go up.
Ready two.
The number of persons at poverty will go down. The homes will be better kept and improved. Children will be happier, probably better educated.
Ready two.
Is that enough?
No, Your Honor, that is
Ready
not
to
enough.
take
The
two.
Constitution requires that there be a public use.
Frame your shot.
And we
Bill, a
believe
little
that
better.
those
That's
words should be left intact. Those public benefits have nothing to do with the use of the land and would only come from a more diverse ownership. We believe we should not remove the words use from the Constitution. We should not divorce the benefits from the use of the land. In this case, those benefits that you described would have nothing to do with the fact that the land was being used as residential homes. And we believe the
Ready,
legislature
three,
cannot
or
merely
four.
choose to favor one
Julia,
class of
maybe you
owners
could give
over
me
another
Seymour
with the
and
argument that
Blackmun, the other
the
shot
new
has.
owners will
Julia
provide more
does.
of a public benefit.
Wouldn't it have something to do with the use?
Can't hear.
That is, I'm not going to be as happy
Ready,
and as
three,
wealthy, and my
take
children will not be as well educated if I'm a lessee paying these very exorbitant rents as opposed to someone who owns it.
Ready two.
Well, no, Your Honor, it has
Two.
to do with the ownership of the land. I will not be as happy if I don't own land.
Ready,
However, I
three.
may be happier if I do own land, but I can still use the land as residential property. The lessees are
Ready.
entitled to use the land
Frame
as
'em-
residential
frame 'em up,
property
Bill, I think
before it is
Chief
taken.
Justice is
Our
looking
argument
for
is that
something.
this court should not allow the dispersed benefits to the
Julie,
public,
let's
which
gamble
may
and go in
accrue
on Blackmun.
from a change in the ownership, to justify a taking when the Constitution requires that such takings be for a public use.
The
Okay.
question I guess I really would
wrong
like to know,
gamble.
Counsel, because
Three.
the problem for us will be what do we do in future cases?
Ready four.
Uh,
Hold your shot four.
Where scope of review
Hold it. Ready
is going
four.
to be important.
On
I'm not
four.
sure whether you're talking about a scope of review that is different from what we've seen in Berman and other cases, or whether you're
Ready,
simply
three.
saying this is
Gonna
just
go
a
four,
very
three,
special,
two.
different case.
Ready three. Take
And
three.
there's nothing that's ever been
On
like it. It's
three.
private to private transfer, and
going
it's
to
unconstitutional, and you don't have to
1
worry
second.
about scope of review.
Ready two.
Well, Your
Take
Honor, we
two.
believe that the scope of review in this case
Bill, let's see
is
your
not different
profile
from
of
what we've
Sheila.
seen in past cases. If the question was one where the local conditions would be very important
Well,
and would
weigh
in
in,
fact
check
be
your focus.
dispositive, as in the case, for
Okay,
example,
hold your shot.
whether a particular piece of land was needed to accomplish a legitimate purpose, then that should be
Ready,
left to the
three.
discretion of the legislature.
So
three.
you're saying in the Puerto
Ready,
Rico
four.
Eastern Sugar
Take
case
four.
is distinguishable on that basis?
Well, we believe the
Ready,
Puerto Rico
three.
Eastern Sugar case is
Take
distinguishable on other bases also, Your
What?
Honor.
Okay.
In that case,
good,
there was an
Reggie. Pull
overall
back a
plan of
little.
land redistribution, where the land was to go to not only squatters
Ready,
on the land
two.
for their residential
Private
use.
to private transfer.
Yes, Your Honor, there was an element of
Ready,
private-to-private
two,
transfer
the
in that
dean of
circuit court
very
case.
nice.
However, there was also
Okay.
the transfer of land to large sugar
Beautiful,
farmers,
Reggie,
to
thank
a
you.
distillery, to a sugar grinding
Reggie,
industry,
back on
and to
Sheila.
expert farmers and industrialists, and agriculturalists for the establishment of proportional
Ready,
profit
two.
farms.
No private to private transfer?
Well, but Your Honor, in
Take
that
two.
case, the use by the private person was
Okay,
to
Bill,
provide a
off-
public
off of
benefit.
Sheila and
The
back
court
on
still
Judge.
concentrated on whether that use would provide a public benefit. And in fact, the court
Ready,
did
four.
rely heavily on the fact that there was an overall plan of redistribution, not just the transfer from the sugar industry to the
Ready,
squatters
four.
on the
When
land.
you read Puerto
Take
Rico,
four.
did you really think, and I don't know who my colleague
Ready,
is, but
two.
did you really think the judges had the faintest idea whether or not there would be any public good resulting from that
Ready
transfer?
two.
You think that they could figure it out in their minds? They had the faintest idea that persuaded them at all?
Take two.
Your Honor, I would argue that they could see in that case the use of the land, and that the use of the land could provide a public benefit. If the land was to be given to a distillery and Puerto Rico had found that their need for a distillery was desperate, then perhaps, and which,
Three, take three.
and the court, then indeed the legislature in that case had found that because of the decline in the sugar industry, they really needed to get the sugar industry back on its feet.
Ready.
Then the court could find that there was a public benefit from that use of the land.
So you're saying if we change this case just a little bit, and Hawaii said, each time we take a block of property, we're going to build a few playgrounds and
Get in
baseball
on
fields
him and hold it. I'll
and maybe a
take your shot. Ready, four.
small distillery.
Take four.
That'll do it.
Bill, you could get into the
Your Honor,
audience.
if that was the predominant use to which the land was to be put, then perhaps. However, if the legislature was going to take a lot of land
Anybody
to
interesting?
provide private homes,
We had
and
that
that was the only
shot.
use to
Get
which
me
most of the
somebody
land would be
else.
put, then I would
Okay,
say it's not that
that's
I
much.
hope you see my
Ready,
struggle,
four,
because I'm not
take
sure
four,
where I draw
hold
the
it,
line
two.
in later cases.
Well, Your
I'm
Honor,
asking.
we believe that if we
Hold it.
leave the word use in the
Ready, two,
Constitution,
take
it's
two.
actually easier
Okay.
to draw the line in later
Going to
cases, because
three.
we can see a use that
Louis
provides
Ross.
some benefit to the public.
Very
And the
nice,
court may not be
very
able to
nice.
tell how much benefit or whether that benefit is the major benefit, but at least if there is a
Back to
visible
two.
use, the court
shots,
can
gorgeous.
review that and
Ready,
determine that
four.
there
Okay,
is
Bill, I'm
indeed
done with that shot.
something that will benefit the public. However, if this court were to determine
Bill, give me all
that
three.
public
I don't know who's
benefits
gonna
or a public
do anything
purpose
next.
were enough to justify a taking, then the line could never be drawn, and the court could never review whether there was indeed a public use or a public purpose for those takings.
Let me
Ready, three, take
press
three.
one thing.
Okay,
You've
Julia,
spoken
can you go in
constantly
on it?
of taking title away from your client. Be
Ready,
simple.
four. Hold it, Julia.
Suppose, well, what does the record show about the
Okay,
length of
four.
these leases,
You're on
the
four.
maximum length of
Bill,
the
you can
leases
get
as
in
a
on
matter
it,
of
too.
practice? 35 years?
35 years.
Ready, two.
So if one builds a house, he has 35 years to
Hold
go,
it, Julia.
That's right.
which isn't very
Ready,
long for
three,
a house.
Take three,
All of us who are
Ready,
familiar with
two.
Cambridge would know that.
take two.
Suppose
Ready,
the
three, take three. We're on three
the
now.
legislation here
Stay on three for a minute.
didn't purport to take the fee simple away, but merely would force in place of a 35-year maximum,
Rajiv, move her over to the
99-year
left. We'll
lease.
try a split.
Would you be here making the same arguments?
Yes, Your Honor, I
Ready,
believe we
take
would,
two.
because a 99-year lease would, in effect,
Setting up the
constitute
split.
a taking of the land. Mr. Makalena would never have the opportunity
Okay,
to get the
Bill,
land
move
back.
him off to the side,
However,
to
that
the right
that
side
would
of
be
your
a slightly
screen.
different
Suppose it were
charge.
50
Okay,
years.
hold it. We're going to do the split. Here we go. We've
I
got
would
two
still
and
say that
three
the
up on the
legislature
screen.
should not have the
Just
power
watch
to
out, Bill, that you don't
regulate
lose
the
him 'cause
time
he
in that
tends to
manner.
move away.
To make any change whatsoever.
Okay, that's looking great.
Not,
Even-
not
even
as
36.
regards, no, Your Honor, not as
Maybe.
regards the ownership of the land. The legislature has the power to
Two and
control the
three are
use
on
of the
the
land
split.
or to take for public use. However, they should not have the power merely to choose one class of owners or one class of long-term lessees over another class.
But isn't that clearly what they're doing in the urban renewal
Julia, get
cases?
me four,
Well,
please.
choosing one class of owners, Your Honor?
Okay.
Yes, but in that
We're on
case,
four.
the
Ready,
distinction I'm
two,
trying to
take
draw
two.
is that in that case, the urban renewal itself was a use which provided a benefit to the public.
Ready,
And the
three.
character of the actor, of the developer in that case, is not as important as the benefit which came from the new use.
Ready,
However,
three.
whereas here, there is no benefit from the use, then this court should not allow those takings to be considered constitutional.
Of course, within this month,
Okay. Ready, four, take
are you
four.
familiar with the Norfolk Authority
Ready,
case that was
three,
decided
take
on
three.
November 1?
Ready,
No, I'm
two,
sorry, Your Honor, I'm
take
not.
two.
Well, I wouldn't be sorry.
Three.
I'm not too familiar with it either, but this was litigation brought by the CMP Telephone Company in connection with urban renewal in Norfolk, Virginia.
Okay, Julia, you can.
The telephone company had its
see that
lines in the
audience anywhere.
urban renewed area, and because everything was adjusted, they had to lay new lines in new streets, and they wanted compensation under certain statutes
Okay, I'll
for
get to it in a minute.
the relocation of the lines.
Hold it nice and still.
This court,
Looks
in
good.
its
Okay.
wisdom, in a 9-0 decision, said no compensation. Does that
Whoops,
offend
I
you
better go to
a little
two
bit
first. Ready, two.
in your position here?
Ready, two.
I'm
Take
afraid I
two.
don't quite
Hold your
understand the
shots,
case well
everybody.
enough to make a decision. There were
Okay, ready for.
That's why
telephone
I said I
lines.
didn't understand it fully either, so.
The telephone lines were taken or
Ready
were merely
for.
disrupted?
Take 4.
They had to be
Ready,
removed, and of
three,
course, the
take
telephone
3.
company said it would cost us more to
Okay,
take them
Julia,
out, so
back
we'll
on the
just
judges.
abandon them. Leave them there in the street. They had to put in new ones, serve their customers,
Ready 2.
But had to be, that were served before by these lines, not only in the urbanized area, but in the areas which the lines also serve.
Well, Your Honor, I don't
Ready
believe
to
that
take
offends our
2.
position because the taking for urban renewal would still provide a benefit to the public. However, I'm not certain why this court would decide not to pay just compensation in that case.
The
However,
telephone company
Ready,
thought
3.
it was entitled to it, and
On 3. Whoops, don't lose them. Thank you. Ready 2.
maybe telephone companies are a little different kind of animal.
Take 2.
They are a public utility.
well, yes, Your Honor. We believe, Your Honor, that in the first instance, this court should
We're on
declare the
2.
statute unconstitutional because it takes for a private use. This court should reach this claim on the
Okay,
merits
she sounds like
and
she's winding
decide
up.
that this statute is unconstitutional. Thank you.
Okay. Bill, you should get on the oralist's
The,
place.
appellants have
Ready
any
for.
rebuttal?
Take 4.
Well, he didn't like us.
You have that
Bill, on the
right.
judges.
Sometimes
Frame them up.
council feel
Frame the
that
3 of
it's
them
either
up.
a sign of complete security or of complete retreat. So,
Okay, ready 3.
well, the court will adjourn
Take
for the moment to
3.
take the case under advisement.
Okay, Julia, pull back. Oops, they'll have to rise. Ready 2. Take 2. Just hold your shots. I'll take whatever I can get here. Ready 3. Take 3. We'll watch them file out. Can you go in on them filing out, Bill? That's looking great. Very nice. Very nice. Okay. Now, hold your shots, everybody, because we're taking shots while they deliberate. Okay. Ready 2. We're on 2. Let's see. You can keep those shots on your camera and get off camera if you want for a couple of minutes. David's coming out. Well, I don't know if they can actually get off camera. I don't want it open. I want it closed. I don't really want it open. I don't want it open. Like my privacy. Okay. Shots are looking good, everybody. Look on the judges. We must have. No, I figured you wanted to do it, but I didn't know where you were. Okay, folks, getting ready. Julia, you're on the judges. Bill, you're also on the judges. And Rajiv, you're watching the council tables. I can't hear anything. I want to hear.
All rise. Court is now in session.
Ready 3, take 3. Ready 2, take 2. Ready 3, take 3. Okay, Blackmun is going to talk. Julia, give me a shot of Blackmun. Ready? 4, you're on the air. Hold it, Julia.
I've asked Judge Edwards and Justice Edwards and Justice Seymour to make
Okay,
some
Bill,
general
check-
comments about
check
the
your focus.
the argument and the
Ready,
evening's
3.
performance.
Okay, hold it, Bill. Take 3. Ready 4. 4, get
I'd like
on-
to congratulate all of
say-
the contestants
four.
tonight.
Bill, get on 4.
Those who
I'm
argued
sorry,
orally, I think,
Janet,
all
but-
showed great presence before us, and I think you did
Ready,
what
3.
court
Take 3.
hopes that advocates will do
Okay, Julia,
when
you
you argue
should
before
get
us. That
on
is to
Seymour, 'cause she's
help
gonna
us to
be
understand
talking
better
next.
the limits of your argument and to get a better grasp of difficult legal
Get in as
questions.
tight as you can.
I have always believed in my tenure on the court that, unlike many who argue otherwise, I think oral argument is an important occasion, especially in difficult cases like this one. And I think the four of you are to be commended for your fine efforts. And
Reaction
when
shot
we
on
probed
two,
a little,
ready
it
two.
was not to make you uncomfortable, but to help us to understand, and that is
Okay,
exactly the way it
reaction
happens
shot on two.
in court.
Hold
So
your
you should
shot
not
on
feel
two.
that you were discriminated against in any way.
Okay. Back
And
to
for those
three.
of you who worked on the briefs, even though you did not appear before us today in
Okay,
argument,
Reggie, looking
you
nice.
are to be similarly
Okay.
congratulated on a fine effort.
Ready,
That is
two,
something that we
take
look
two.
at as well and spend a lot of time with before oral argument to get ourselves ready for
three,
oral
take
argument
three.
and to assist us in understanding the case. And I've enjoyed the occasion because I think we saw real professionalism,
What was that?
great presence, and you gave great assistance to the
Rajiv,
court.
close down your
Thank you
iris.
for that
Your shot is
performance
looking
today.
different. Ready, four. Take four.
I found this to be the most
Okay, Bill.
difficult moot court I have sat on in terms of weighing both the briefs and the oral argument. I have great sympathy, especially for the brief writers, because 19 years ago I was on that side of the bench in the Ames
Ready,
finals,
two.
and
Take two.
Justice Stewart
Ready,
was
three.
Chief Justice of my panel,
Take
and I
three.
remember him specifically saying that
Are you in focus,
the
Bill?
briefs and the oral arguments were of the quality that were among the highest
Ready,
of the
four.
good
Take
briefs and
four.
oral arguments that he saw on
Hold
a
it,
regular
hold it,
basis, and I
Julia,
thought
you're
at the
on the air.
time he was just being nice to us. But having sat on this side of the bench for 4
Ready,
years
three.
now, I can tell all of you that the quality of the briefs and
Dissolve
oral
into
arguments
three.
are very high. And that's
Hold
what
it,
makes
three,
it
you're on
particularly
the air.
exciting to sit on a moot court
Ready,
such as
two.
this.
Take two. Okay, back on Blackmun. Everybody, back on Blackmun.
I don't know whether I can add very
Ready,
much,
three.
but let me make a
Take
comment or two.
three.
I join Judge Edwards and Judge Seymour in their comments of congratulations and compliment to you. The case, as you know,
Ready.
the case you've
Ready,
argued
two.
is very similar to, closely resembles real cases that were noted by the Supreme
Ready,
Court
two.
on the 31st day of
Julia,
October.
hold your shot. Ready, two.
And we have this
Dissolving to two.
very profound and difficult Hawaii legislation coming before us. I suppose it'll
Ready, three.
come
Take
probably in March or April. I hope
Julia,
it's
let
not
me have
April
all the
because that's the
justices,
last
please.
argument session. I hope it's March. We'll need a little more time than what April gives us. And there appear to be good counsel on both sides. I
Okay.
say that with
Be
some
ready for
trepidation
your
here,
winners,
but
guys.
as you know, Professor
two,
Tribe
take
and
two.
Kathleen Sullivan are
Ready, three.
representing
Take
the
three.
Hawaiian Housing Authority in the real cases. And on the other side,
Ready, four.
is Barrett
Julia,
Prettyman
give me
Jr.
a
and Hogan
close-up of
Hartson and
Blackmun.
other names. I've
And I-
understood Mr. Prettyman may be present here tonight,
Ready, four.
and
Take
so
four.
I have to be a little careful in my comments. But
Bill,
yes, I see him
if
up
you
there.
can
He is here.
I don't know
But
where he is.
I look forward. The case will be well
I don't know
represented
I don't
on
know who
both
they're
sides,
talking about, so we can't.
and that's always
Bill,
a comfort.
Get me the other council table. See what you
It's
can
the
give
kind of a
me
case I
that
would
is
think
not
the council would love to get
Sheila's
into,
table, that's the other
both
table.
because there are
Now it's going to be too close to
clients
you.
with substantial interest involved and great
Yeah.
concerns,
Yeah, never mind, I
and
can't- it's no
the
good.
clients themselves
won't
are able
work.
to pay.
No, no good. Back on Blackmun. Ready, three. Take three.
What do you really think, those of you who worked on the briefs and the oral list, what do you really think of the merits?
Ready, two.
Have you convinced yourself as you worked in this, both on the procedural aspects and on
Ready,
the
one.
merits?
Take one.
I think this is part of the
Rajiv,
fun,
can you get
really.
me the other team at all? Let me just see. I'm off your
That's
shot.
what lawyers, I suppose,
Okay,
should do,
stay on the
although
other side.
on the criminal side, we can't always say that we
Ready,
believe
two.
so strongly in the innocence of our
No, no,
or
no. Stay on the shot that you
defendant.
just had.
I, of course, cannot comment on the merits
Okay,
because
frame
it
up
would
nicely.
be inappropriate for me to do so if I knew
Ready
how and if I had
to-
anything to say, because the litigation will be before us.
Okay.
I think that you'll all
Ready
look back on this
for-
evening and this experience. I hope you will. And I hope you will look back on it as one of the highlights of
Take
your
four.
law school career. And I say that even though
Okay,
you don't
Rosie,
win.
Stay on that team, okay?
If you are not named the winning team or the best oralist, this isn't
Ready,
the end of the
three.
world for you.
Take three. Ready, two. Take two. Ready, three. Take
Someone
three.
always has to lose. This is the nature of our profession.
Ready, two. Take
Uh,
two.
And you feel it just
Ready,
as strongly when you're on the downside of a 5-4 opinion that comes out of the court. But it's the nature of litigation, and that's what we,
All right.
I suppose, are lawyers for. I never believe anyone who says, I have a lawyer, I think he's great, he's never lost a case in his life. And then, of course, you know that he hasn't had any.
Ready, four.
So that
Take four.
I think I can assure all of those in the brief and certainly the oralists that
Rajiv, it's going
you
to be up to
will
you to
succeed.
pick up the appellant and the appellee.
you'll succeed in this very
'cause Bill
strenuous
can't
and
get to
difficult
him.
and competitive profession of ours. And I suspect you
Ready,
will never
three.
be maybe so bored with
Hold
an
it,
actual
Julia,
case
hold it,
as you
you're on
must
the
be
air.
with this one
Hold
by
it.
now. But a couple of
Ready,
observations
three. Ready, hold your
that
shot, Bill. Hold your shot.
I believe in. I
Ready,
think
three.
cases basically are won in the trial courts.
Take three.
Not always, but most of the time. And sometimes in moot court programs, we tend to emphasize, of course, we must
Rajiv, your
emphasize
shot
appellate
is looking
advocacy.
washed out now.
But
Just
don't ever forget
try
the
opening up the
importance
lens a
of
little.
winning
Okay, hold it right
in the
there.
trial court, in the district
Okay.
court, or the circuit court, whatever it's called. Know your facts, and I compliment all of you
We're gonna
in
get a
knowing your facts.
reaction shot on two.
People ask
Resolving
about
to two.
answering questions, and you should answer questions when they're asked, as you did
And hold
tonight.
your shot. Back to three.
We can always tell, I think the judges, appellate judges can always tell when counsel are being evasive. And
Okay,
I think
Rajiv,
you
yeah,
should
give me
never be
that.
concerned when
Give me
your
that.
nicely prepared oral argument goes down the drain. It often does. And if it doesn't, it's usually because the judges are sleepy and they're talking about other things.
to
And
close down your
as
lenses
Byron
a
White
tad
will
like
say,
you
Harry,
had
who's that
before.
guy sitting in the second
Open
row
up
on the
your
left?
Ready, three.
And I say, Byron, I'm trying to listen to oral argument.
Could Julia give me the three justices, please?
He's a great benchmate. He's been next to me for 14 years,
Tilt down a
and
little bit, Julia.
he's lent many a light moment as well as a desperate one on occasion.
Check your
But
focus.
know also when to sit down. We have counsel coming down there with 30 minutes, and they're through in 10, and then they start all over again,
Ready, four.
and then they start over for the third time, and just to finish up the 30 minutes. I think you should appreciate,
Ready,
too,
four. Take
that
four.
on occasion, the questions that are being asked often amount to argument among the justices. Justice Rehnquist on
Ready,
my
three.
left will be arguing really with Justice Marshall down on the other side. And
Ready,
while the
three.
questions are directed to the poor guy who's trying to
Resolving
present
three.
argument, they're really
Okay,
testing
Bill,
each
that's a good
other
shot.
out
Hold
in
your
their
shot.
respective positions. This case, of course, is in a developing area of law, and I think it was a great case, although a hard one to have for oral argument. It don't overlook
Drawing this-
legislative history in federal cases particularly. I think I could say in summary, and what one usually says at a moot court argument, and that is that we wish that every oral argument before us in real cases
it,
were
Bill,
as
you're on
well
here.
done and as well presented as the one tonight. I think one can say that in law schools over the country, really, because student oralists who give so much of their energy
Okay,
and
I'm gonna
time in
dissolve
these moot court appellate advocacy matters, really put themselves into it, and generally do much better than the average actual real presentation.
What am I doing now?
And that applies to the
Hold
Supreme
on,
Court of the United
Hold on,
States.
two.
I hope this will always be remembered
three.
for all of you as a happy day in your life.
Take three.
Not only a strenuous one, but as a
Rajiv.
happy one.
Let's
And
see
that
who's gonna win here.
many years from now, you'll look back on it as a time when you were in the midst of the motion here in Austin Hall. Let me chide the preparers of the case just a little bit. This is pure trivia, but being mischievous, I have to do a little bit about it. On page 28 of the appendix,
Ready for,
in
Take
the
four.
dissenting opinion, it reads, the majority begins by asking the wrong question. It believes that it must, and I
two.
quote,
take two.
decide whether the federal Constitution permits a state to take the private
Ready,
property
three.
of A and transfer its ownership to B
Take three.
for his private use and benefit.
Nice, Rajiv.
I would assume, because those words are in quotes, that that is a
Ready,
quotation from the majority opinion. I and four of my clerks searched the majority opinion in vain
Ready, three.
and did not find it.
Take three.
Secondly, on page 30 of the appendix,
Take two. Ready, three.
I was mildly amused, and this is completely irrelevant and trivial. The docket number is number 83920, and the date on the noting of probable jurisdiction is March 7, 1983. Well, that's in the October term 82, and the 83 numbers hadn't started until the beginning of the 83 term, which is in July. And then I always jump. I'm enough of a
Reggie, let's
perfectionist.
have the
I
other
jump
team.
when I see a testamentary
this
gift
after a
of real
while.
estate described as a bequest. When I sat at somebody's feet
Okay, hold
here in
it.
Austin Hall 100 years ago, we were told that a
Ready,
testamentary
two.
gift of real estate was a devise, not a bequest. Isn't it fun to kind of
two.
pick on your superiors? Well,
Ready, three.
as I say, nothing
three.
very important about that, and so now we come to announcing the
Lovely,
results.
Rajiv. Okay, Rajiv, here comes your big
I'll never
number
forget
here.
one time I sat on a moot court at Washington University when the presiding judge announced as the winners the people who were actually the losers, and had to backtrack, so I want to look at my notes very carefully.
Okay, Rajiv.
That was a horrible evening. I mean, we are first to state the best brief,
Ready, two.
and we have decided after a certain amount of analysis and soul searching that the appellees have
Ready,
a
two.
bit the better of the brief, and so
Ready,
we
two.
regard the appellees as
Okay.
having the better
Those are
brief.
the appellees, I certainly hope. Ready, three.
The second
Take three.
is the best oralist, and this is always excruciating and difficult. And I think each of us realizes how difficult it would be if we were out in your places. But
What's your best bet, Rajiv?
we've decided that the best oralist is Linda Bradshaw.
Ready, two. Take two. Ready, three.
And then finally, the team, and our decision with trepidation and concern is that the appellees
Ready,
are the
two.
winning team.
Take two.
up.
Guess that's it, folks.
We're going to do what they do in the Fourth Circuit and come down and congratulate you.
We're on two.
Congratulations.